You're on board the Newstrack. The Supreme Court of India has held lawyer activist Prashant Bhushan guilty for contempt of court for 2 tweets against Chief Justice Bobde and 4 other former Chief Justices. The verdict has ignited a massive debate over freedom of speech and the law of contempt. Several civil rights activists are asking, is the judiciary above criticism?
If an attack is made to shake the confidence that the public at large has in the institution of judiciary, such an attack has to be dealt firmly. This is what the Supreme Court said in its order pronouncing Advocate Prashant Bhushan guilty of contempt of court. The advocate had tweeted against the sitting CJI and previous Chief Justices. 2 tweets by Bhushan posted on 22nd July and 27th July prompted a suo motu contempt case against him in the apex court. In his defense, Bhushan argued that the tweets were a bona fide criticism on the conduct of some judges made in good faith and in public interest. But the court considered the tweets false, malicious and misleading. One of Bhushan's tweets was about a photo of CJI SA Bobde on a Harley-Davidson bike during the coronavirus lockdown. The court said Bhushan was aware the photo was taken during court vacation and that the Supreme Court did not shut down and held hearings via video conferencing. The contempt proceedings against Bhushan had drawn concern and criticism from civil society members. Senior advocate Rajiv Dhawan says, contempt cannot be a sprawling jurisdiction which encompasses everything, especially scandalizing the judges. The law says that bona fide comments, however irksome they may be, are protected by Article 19, freedom of speech.
I don't think it was really necessary for the court to actually have embarked on this at all. The application that was made was clearly not maintainable and it should have been rejected at the outset and matters should have let to lie. The court has been faced with criticism of many hues over many years. I find it a little regressive that the court has decided to go in such detail into some comments which were made by a practicing lawyer.
Advocate Shekhar Naphade says, who decides what is bona fide criticism? We need an in-house debate on this. We have to evolve some system by which the grievances of lawyers and litigants can be addressed.
As the court in its 108-page judgment has said that the tweets made by Advocate Prashant Bhushan are not a fair comment on one judge, but an unfair and malicious attack on the integrity of the institution itself, as well as of the institution of the Chief Justices. The court has held him guilty of contempt of court and has also said that as a member of the bar for over 30 years, this was not expected from such a senior lawyer. In New Delhi, this is Anisha Mathur for India Today.
Let's kickstart the Newstrack showdown. Joining us on this broadcast, Gaurav Bhatia, representing the ruling Bharatiya Janata Party, is also an advocate in the Supreme Court, squaring off against him. We've got Sanjay Hegde, who's a senior advocate at the Supreme Court. Let me go across to Sanjay Hegde first, because it's not as if Prashant Bhushan has been a long-standing critic of the contempt law per se. A lot of people are citing the fact that in 2013, the UK scrapped the law of contempt because when in December 2017, former Calcutta High Court Judge C.S. Kannan's case came out, at that time, Prashant Bhushan in fact tweeted in support of the contempt charges. Glad SC finally jailed Kanwal for gross contempt of court. He'd made reckless charges on judges and then passed absurd orders against Supreme Court judges. So if he was okay with what happened with contempt, then why is this problematic now? Let's start with Sanjay Hegde.
Well, Prashant Bhushan is not Justice Kanwal. Justice Kanwal, while a sitting judge, did several things. That's all a matter of the record. Contempt law is on the statute book specifically for somebody who interferes in the course of justice. Contempt law is also there to restore public faith in the administration of justice. Now, the current judgment about Prashant Bhushan, I think, was a mistake, is a mistaken call on the part of the judiciary. I do not see how the public's faith in the authority of the court is restored by saying that Prashant Bhushan's two tweets with regard to a motorcycle ride and with regard to his perception as to what history will record constitute contempt of court.
Okay, so let's get Gaurav Bhatia.
To unfair criticism, okay. But I don't think it was contempt.
Okay, Gaurav Bhatia, one is a comment about the judge riding a 50 lakh rupee motorcycle in Nagpur without a helmet in the middle of a corona crisis. A lot of it is factual, some of it is his, some of it is his extrapolation and his judgment, but a lot of it is just a description of the fact that the judge is without a mask and everybody else is standing around in Nagpur in the middle of a pandemic. The second is about how history will judge the last 6 years. Now that is Prashant Bhushan's assessment of the current situation. Good, bad, ugly, you agree with it, disagree with it, that's your wish. How does that constitute contempt in your view? You're an advocate yourself.
Yes, Rahul, first of all, I welcome the judgment of the Honorable Supreme Court. And the reason is very clear. It should have happened long time back. People like Mr. Prashant Bhushan, though he's a colleague at the bar, and I'm pained to say this, but these people are habitual offenders. We have seen time and again, they browbeat the judges, they make an argument, and if it is not accepted, they come out of the court and they make scurrilous remarks. Let me first discuss these two tweets that we are talking about. The first tweet says that while the CJI rides a 50 lakh motorcycle, the Supreme Court is in lockdown. He forgets to tell everyone that even an FIR registered against him was stayed by the Honorable Supreme Court. The Supreme Court has been functioning. And the more serious charge is made in the second tweet, Rahul, where he says without any evidence, without an iota of any material, he alleges such a serious charge that 4 former Chief Justices have destroyed the democratic structure of our country. And also let me place this on record that in 2010 also, a similar remark was made against former Chief Justices, where he said that out of 16, 8 former Chief Justices of India have been corrupt and a notice was issued. So I would only say criticism is fair. Even Supreme Court judgments can be criticized. But it is nobody's business to make scurrilous remarks without any basis and evidence.
Now Yogendra Yadav, Gaurav Bhatia's argument is Prashant Bhushan is a habitual offender. Each and every time he goes to court, if the judgment doesn't come in his favor, he comes out and casts all manner of aspersions on the judges and alludes motives to them, which is not the right thing to do. And at some point in time, he ought to have been taught a lesson. Yogendra Yadav.
Mr. Bhatia is entitled to his views of Prashant Bhushan. Mr. Prashant Bhushan is entitled to his views. How can I prevent Mr. Bhatia from having his views? What I found amusing was his use of the word without an iota of evidence. That's a lovely expression I like. I thought Prashant Bhushan filed a affidavit which is 134 pages. I have read every word of it. It has paras are pages after pages of evidence, and incidentally, some of which Mr. Bhatia finds not an iota of evidence is actually words of the judges of the Supreme Court themselves when they were the judges. Remember, there was a press conference held by 4 judges of the Supreme Court. Maybe Mr. Gaurav Bhatia has forgotten that. Some of the judges gave statements after they retired about what was happening. This, incidentally, also includes a lot of statements made by some of the best jurists of the country. Prashant Bhushan is not the only one. Mr. Bhatia can disagree. We can agree to disagree. But to use that ultimate power to say we shall use contempt of court, which is only used in those instances where you find administration of justice is not possible. So you are doing something which makes it impossible for me to run a Supreme Court. If I hold an agitation and do not allow the judges to enter the Supreme Court, sure, I'm inviting this. If Supreme Court passes a judgment and a state government says we will not implement it, surely they are inviting contempt of court. But for the Supreme Court to say, and I'll just read out those lovely statements that the Supreme Court has made today, I want some of us to know what the court has been saying today. The court says, and I quote, an attempt to shake the very foundations of constitutional democracy have to be dealt with an iron hand. This is not a superintendent of police. This is not a Thanedar speaking. This is the fountain of justice in this country speaking. The tweet has the effect of destabilizing the very foundations of this important pillar of Indian democracy. The foundation pillar of Indian democracy is not threatened when the CJI of India holds the court on Saturday and listens to his own case about sexual harassment. That does not shake the foundations. And Prashant Bhushan's tweet shakes the foundations of this country.
Okay.
What are we talking about?
So, Gaurav Bhatia, one of the cases being heard dates back to 2009 in the Tehelka case, which hasn't been heard in the last 8 years. We're in the middle of a COVID crisis. Several cases, including those like the Citizenship Amendment Act, including those on the habeas corpus about Jammu and Kashmir, haven't really been heard with any sense of urgency because it's been said that there is no extreme urgency. Now, these two tweets become the matter of most burning urgency for our honorable judges. Gaurav Bhatia?
Okay. So, Rahul, because I am also a foot soldier of the Honorable Supreme Court, let me just say something to my friend Yogendra Yadav ji. Yogendra Yadav ji, in 2010, the comment I was referring to, made by Prashant Bhushan and Shanti Bhushan ji, they said that out of the last 16 Chief Justices of India, 8 have been corrupt. Last 10 years, they could not even produce an iota of evidence. That proceeding is still pending before the Honorable Supreme Court. Now, if Prashant Bhushan...
You've not read the case pages. They have produced hundreds of pages of evidence.
Myself? Why do I have to be interrupted? Did I interrupt you? Are you on a weak wicket? Please, sir, please. Prashant ji, I think we should extend each other this courtesy. That while one is speaking, the other one will listen. You will get your time to rebut. Please. I respect that. Please. Okay. So, Rahul, nobody has been vindictive. Since 2010, if Prashant Bhushan was to be targeted, that case could have been clearly adjudicated. My second point is Ayodhya matter. Prashant Bhushan ji, I am a lawyer. Mr. Hegde is here. Is it appropriate for a lawyer to throw files? And it is recorded in an order of the Supreme Court. A senior advocate, I don't wish to name, but I am raising an important issue, threatens the court that we are walking out of the court if you hear the matter on a day-to-day basis. This is not what lawyers are taught. Second, judge-lawyer matter. The verdict came different from what these people thought. What did they do? The very next day, a political impeachment was brought. And I will tell you, if you have a problem with a particular judge, you can write to the Chief Justice of India, and if it pertains to the High Court, to the Chief Justice of the High Court. Second, the Bar Association has also been raising these issues. But to cast aspersions on someone's integrity is not acceptable.
Rahul, just one thing I want to clarify. I'm sorry I interrupted Mr. Bhatia. I want to clarify that once again he's saying that Mr. Prashant Bhushan has not produced an iota of evidence, having said half the CJIs are corrupt. It is blatantly false. Prashant Bhushan has filed 3 affidavits in the Supreme Court. The first one is largely about Justice Kapadia. The second affidavit, which runs into hundreds of pages, names each of those 8 judges, gives detailed descriptions of their misconduct, corruption, which is not necessarily involving finances. And the third affidavit is about Justice Balakrishnan. Put together, these three affidavits probably are about 400 pages, and the annexures run into another hundreds of pages. So Prashant Bhushan has not made any loose accusation. Every single accusation has been charge is accompanied by detailed documentary evidence. So my friend Bhatia may agree with the evidence or not, that's all right. But for him to say Prashant Bhushan has not provided an iota of evidence in the last 10 years, this is blatant falsehood.
Sanjay Hegde, should the judges of the Supreme Court not have had the broad shoulders to take the criticism in their stride? From the judgment, it appears that the judges are taking the view that if everybody goes out and starts casting aspersions on the judges, it impacts how they function, it impacts how the general public perceives them, and if you do so on a regular basis, you're almost casting aspersions, because if you don't like the judge, you don't like his judgment, you go out and tarnish his image.
Well, should the court have had broad shoulders. The court in this judgment seems to say that, if it had been an ordinary man, we would have kept quiet. But this is Mr. Bhushan, who's been there for about 30 years, who's been a lawyer, etc., etc. On whether they should or they should not, let me tell you a story from the Calcutta High Court. In the Calcutta High Court, there was a question of what constituted skin and what constituted hide. This was an excise matter, the difference in classification between the two commodities. So the judge got confused and said, ask the counsel, what's the difference? So the counsel looked at him and said, my lords, when I was young, I had skin. Now I have hide. I think that the judges of the Supreme Court, right at the end of their careers, are seasoned judges. They should have the broad shoulders to shrug off. And most importantly, they should also know that using contempt brings the institution itself, which consists both of bar and bench, into further controversy. Have they increased the authority of the court by taking action against Prashant Bhushan? Well, I will let history be the judge, and I hope nobody takes it.
Okay, Gaurav Bhatia, I'm also running out of time, so final words. When the public at large looks at those tweets, looks at the fact that he's been found guilty, they'll wonder, what's the big deal? Is this, I mean, you can agree or disagree with him, and no one needs to be a fan of Prashant Bhushan. But you look at those tweets and you say, is this not judicial overreach? And does that then not, in the eyes of the larger public, lower the esteem of the institution of the Supreme Court, which is preserving, which should ideally be the main responsibility of the sitting Supreme Court judges?
Okay, let me quickly summarize it. The Honorable Supreme Court is one of the most respected institutions in the country. And the reason is that judges after the independence have dedicated their entire life to serving people. But I'll also tell you a small story, if you allow me to, that do remember that Karnataka Assembly case, when at night the Congress government wanted that a floor test be conducted. It was the very same Supreme Court that allowed that. There was a hearing at 3 a.m. in the morning. I have a tweet. It's an example of how people cast aspersion on the judges. It's by a very renowned journalist. I'm not reading the name. And he says that, no, Judge Arun Mishra, who recently described PM Modi as a versatile genius, is the one who basically is not allowing the Rajasthan High Court from delivering the judgment, or is refusing to restrain the Rajasthan High Court. And second, Prashant Bhushan ji earlier also has been indulging in forum shopping. I can give you many examples. So there are at least more than 50 tweets, Rahul, where Prashant Bhushan has made such scurrilous remarks. You can find those tweets on his timeline. That is why I say he's a habitual offender, and the Honorable Supreme Court has just done the right thing.
Okay, Yogendra Yadav, I'm completely out of time, but since you have your hand up, I'm going to give you 30 seconds to respond very quickly, please.
I have a story, and it's about a possible future story. God willing, that will never happen. Suppose there is a CJI who is in league with the ruling party, against whom obviously you cannot have impeachment. And if you have honest, correct criticism of that judge, how will you express it? Unfortunately, the Supreme Court has closed that door today. Today's judgment is part 1 of ADM Jabalpur being replayed. I really hope that on 17th and 20th, we do not have part 2 and 3 of ADM Jabalpur judgment once again.
You know, I don't wish to take sides on this debate one way or the other. As always, we put out forcefully argued points on both sides of this divide and leave it to you, our viewers, to decide where you stand. But should the Supreme Court judges have reacted in the way that they have, even if they're no fans of Prashant Bhushan, is this really worthy of contempt at a time when in 2013, the United Kingdom and our contempt laws are based on UK jurisprudence? They've struck down contempt laws from their book, saying that you can't scandalize the reputation of the Supreme Court by saying something. The Supreme Court is way above that. You know, is that not something our judges need to reflect on as well? This is where I want to thank Gaurav Bhatia, Sanjay Hegde and Yogendra Yadav for joining us on the Newstrack. We'll have more for you tomorrow evening at 8 p.m. Till then, from all of us here, goodbye, good night, and wish you a very, very happy Independence Day. See you.
Hi everyone, Preeti Chaudhary here. Hope you like this video. For latest news and analysis, Like and subscribe to the India Today YouTube channel. And don't forget to press the bell icon to stay updated. Thank you for watching.